to have you join us for what promises to be a very engaging and insightful discussion. My name is Sonia Głogowska, and I will be your moderator during this event. This webinar about the universality of the Rome Statute is very special for us, as it is the first in the expert webinar series. And this series is brought to you by the Foundation Sunflowers, together with the Kraków Center for International Criminal Justice at the Jagiellonian University. Before I start, please note that this meeting is being recorded, and the recording will be available later on Foundation channels. Today, we are honored to have Dr. David Donat Cattin, a renowned expert in the field of international law and human rights law, as our featured guest. I will be very happy to introduce our main speaker shortly, but before I start, I would like to invite the organizers to say a few words of introduction. So first, please welcome Dr. Ewa Hofmańska, the President of the Executive Board of the Foundation Sunflowers.
Thank you, Sonia. Good evening, good morning, good afternoon to everyone. Dear all, it's my great pleasure to open today's webinar. Actually, there are two reasons for this enjoyment. The first is that today's event has been organized by two unique entities, as Sonia mentioned, Kraków Center for International Criminal Justice and Foundation Sunflowers. As you all know, the Kraków Center is the only research center in our part of Europe that deals scientifically with issues related to international criminal justice. Foundation Sunflowers, which I have the honor to lead, is the only Polish civil society organization designed to support the efforts of international and national actors in bringing justice where genocide, war crimes, crimes against humanity, and crimes of aggression have occurred, and to support the efforts of those responsible for preparing reparation programs for the victims of these terrible crimes. In June 2024, Foundation Sunflowers granted the Kraków Center the status of Foundation Partner. Today's webinar opens a series of expert webinars that the Kraków Center and the Foundation will be organizing. Just a reminder that the Foundation also organizes educational webinars and trainings for practitioners. Over the past 36 months of the Project Sunflowers activities, we have organized as many as 17 educational webinars and many specialized trainings for practitioners. Together with the International Center for Multigenerational Legacies of Trauma, we organized a series of webinars on reparative justice, which were very successful. I encourage you all to visit our website, where you can find recordings of the webinars organized so far. I am confident that the series of expert webinars will not only attract the attention of established professionals in this field, for whom it will be a great place to exchange opinions and discuss lots of issues, but will also attract the attention of those who are taking their first steps in this area. I wish all of you fruitful discussion today and invite you to participate in future webinars of the series inaugurated today. Thank you for your attention. Sonia, back to you.
Thank you very much. And now I would like to invite Professor Piotr Hofmański, the director of the Kraków Center for International Criminal Justice.
Okay, thank you, Sonia. Thank you, Eva. Good afternoon, everybody. Good afternoon, David. First of all, representing the Kraków Center for International Criminal Justice, I would like to express my great satisfaction in the launch of the series of the seminars that the previous speakers have mentioned. The number of people attending today's meeting is undoubtedly a good omen for the series starting today. Today's webinar is the first in a series and immediately completely unique. Firstly, because today we have an extremely interesting and current topic. Participation in the Rome Statute system turns out to be crucial in times of political crisis, and the lack of major political players within the ACC family seems to be pivotal for the success of the entire project. It seems that the ICC, albeit with limited territorial and personal jurisdiction, is able to function if those play a key role in the political arena of the world do not interfere. In the area of tense political relations, it is not only about who is missing, it is also about the fact that those who are missing exert enormous political pressure on others, including the states that are parties to the Rome Statute. This is clearly visible when one notices the lack of willingness to cooperate with the ICC, which turns out to be weaker than short-term political interests. It must be said loudly today that international criminal justice needs unconditional support from all those who are close to the ideas of global security and justice. And the second reason for the uniqueness of today's webinar is the person of the speaker. I'm extremely grateful to Professor Cattin for accepting our invitation and tackling a difficult and politically sensitive issue. I do not know anyone who would have made a greater contribution to the struggle for the implementation of the idea of the universality of the Rome Statute, and no one who would have more comprehensive knowledge about the subject. Thank you, David, for accepting our invitation. And before we listen to your introduction to today's discussion, I would like to ask the moderator to present the profile of today's speaker. Thank you for your attention. All the best with the discussion. Sonia, back to you.
Thank you very much, Professor, for these insights. And now, without further ado, it is my pleasure to introduce our main speaker, Dr. David Donat Cattin, who is Adjunct Associate Professor of International Law at the New York University Center for Global Affairs. Professor is well known for his research and publications concerning international law, in particular the International Criminal Court. His academic work is combined with a career in the civil society and non-profit sector, which led to his election for 3 consecutive terms as Secretary General of Parliamentarians for Global Action, which is the largest international network of individual legislators from all regions of the world. And at PGA, he informed and helped to mobilize parliamentarians who promoted the universality and effectiveness of the Rome Statute system in more than 120 countries, contributing to the ratification process of 78 of the current 125 states parties, while supporting the national legislative process of 37 countries. He recently joined the scientific committee of the Global Initiative Against Impunity, which is a global civil society consortium for justice supported by the European Union. Today, our guest will be sharing with us the key insights on the universality of the Rome Statute. And as Professor Hofmański already mentioned, this presentation should serve as a starting point for the discussion that will take place afterwards. And I also deeply encourage everyone to participate in this discussion by sharing your questions and thoughts. It is also possible to use the chat box throughout the presentation to type your questions as they come to your mind. However, I will open the floor for discussion only after the presentation, so you can also save your questions and thoughts for this time. So please join me in welcoming our experts. Doctor, the floor is yours.
Thank you very much, Sonia, and allow me at the outset really to thank Judge, Professor, President of Mansky. He did so many things in his life, and of course the Krakow Center for International Criminal Justice at Jagiellonian University, with which I'm particularly attached, because when I was a law student, a second-year law student, it was the first foreign university that I visited to attend a seminar of an organization through which then 5 years later, I would have participated in the UN proceedings towards the creation of an international criminal court. I'm talking about the winter, spring of 1990. Okay, I was second-year law student, and there was a seminar at the Jagiellonian University entitled "A Revolution Without a Revolution: How to Change the Legal Systems of Poland and all the rest of Eastern Europe in accordance with human rights standards." So that was an enormous experience that really opened my eyes to international law and international cooperation. Again, I was a second-year law student, and I'm very grateful for this opportunity. And of course, let me once again pay a tribute to Judge of Mansky. I want to invite all the law students, I hope there are a lot of law students here, to read his minority opinion regarding the fact that probably the most prominent person that was brought up to the appeal chambers at the ICC should have been convicted beyond reasonable doubt, referring to the very famous Jean-Pierre Bemba case. And certainly the opinion expressed by Judge of Mansky together with Judge Monaghan, I'm not mistaken, I believe, is persuasive, whereby unfortunately the minority opinions expressed by other two judges on one side and another judge on the other is including a number of arguments that are based on flawed legal reasoning, in my humble view, on a point of view of international criminal law. So unfortunately, the outcome has been negative. Yet, when President of Mansky became president of the court, he probably did the most important presentation, public presentation, in the life of the International Criminal Court as a whole. All right? So when he was the one going on video announcing to the entire world that an arrest warrant had been issued for a sitting head of state of a permanent member of the United Nations Security Council, I think that was the highest moment in terms of the impact that the International Criminal Court is having. And this is something that, hoping that there will be a just peace for Ukraine, Russia, and the rest of the world, that's something that will stay, that arrest warrant, and is bringing about clarity in international relations. What do I mean here? I mean that the most important element of international criminal justice as we know it today is not to do what we do in domestic courts, which is, fulfill the entire justice process. That's really what we try to achieve domestically, because we exercise national sovereignty over our territories, our nationals, our landscape, national interest, protected interest, the cyber digital dimension. Today, we don't know where we are today. We are on the internet. Where are we territorially? We don't know yet. It depends where you connecting from. But in the understanding of the way the rule of law works, that's what we want to achieve with domestic justice. Am I correct? But international justice is not yet the manifestation of an international rule of law, because an international rule of law does not yet exist, because we don't have a world government, a world parliament, and we only have a commencement of a global judiciary. And the ICC is certainly its highest manifestation, insofar as it is a court that adjudicates on the basis of the principle of individual criminal responsibility. It's not a traditional arbitration court like the International Court of Justice that adjudicates on interstate disputes and on the law of state responsibility. Here we are talking about real individuals who should, if found guilty beyond reasonable doubt, be deprived of their personal liberty. This is the strongest element of national sovereignty. The hardcore of national sovereignty is represented by penal law, which, as our common teacher, I believe, in this room, I see also Professor Wilinski, our common late teacher, Professor Sherif Bassiouni, as well as, if I can mention, Professor Dr. Otto Trifterer, our great master, taught us. This is the extrema ratio of criminal law, of national law. The international criminal law is the extrema ratio in international law, as criminal law is the extrema ratio in national law. So we go and punish the person who are guilty of the most serious breaches of the legal order, both domestically and internationally. Yet internationally, we haven't created the same infrastructure that we have domestically. So we cannot pretend that this system is as effective as a national system. That would be the wrongful starting point, okay? Why am I doing this caveat? Because I'm a public international lawyer, not a criminal lawyer. So I bring with myself the luggage of understanding where sovereignty lies. So, as Judge Ovmansky told us, the court jurisdiction is restricted by two factors: territoriality or active nationality. In other words, and I was going back, preparing this presentation on universality, I was going back to read the statements by the big powers when the Rome Statute was adopted. And a couple of them, I will not name them, made a mistake saying that we don't like a court with universal jurisdiction. Therefore, we vote against, or therefore, we, for other reasons, including this one, we will vote against the adoption of the Rome Statute. Remember, in Rome, on the 17th of July, 1998, the United States of America requested a vote. 7 states voted against the adoption of the statute, including, of course, the United States and the People's Republic of China. The Russian Federation voted in favor of the adoption of the statute. It was the time of President Boris Yeltsin. And India abstained. So these are what I consider the main global superpowers of today. 3 of them have a permanent veto at the Security Council. The 4th one is the largest in terms of population, and soon to become maybe the 2nd or the 3rd or the 4th economically in the world. We will see. While 120 states voted in favor, 21 abstained. As of today, 125 states joined the Rome Statute, including 124 states invited to the Rome Conference. Unfortunately, the Cook Islands, as a state in free association with New Zealand, is not a United Nations member state, so it was not invited to participate in the United Nations Diplomatic Conference for the establishment of an ICC in Rome, 1998. But it decided to become a state party to the Rome Statute, also thanks to the work of my former organization, Parliamentarians for Global Action, and my own advocacy with the EU, ACP-EU Joint Parliamentary Assembly, Africa, Caribbean, Pacific, European Union Joint Parliamentary Assembly, 2008, Ljubljana. I think what is symbolized by the arrest warrant against the president of the Russian Federation is at the same time the most powerful demonstration of the impact of the court, which will not be dismantled tomorrow or after tomorrow when there will be a ceasefire agreement or whatever settlement of the ongoing armed conflict, however we will name it. Certainly it will not be, you know, an arrangement towards forever peace, but one day we hope for that. At the same time, it shows the limits. It shows the limits because we are confronted with a sitting head of state that might use or even abuse of his powers to block the entire system of international criminal justice, which didn't happen, and I'm sure it will not happen. At the same time, we see other states taking other measures to try to render the system ineffective, whereby I also believe that they will not succeed, based on other considerations that we will carefully look at. Okay, so that may be the last part of my presentation. And if I forget about addressing the current relationship between the United States and the ICC, you will remind me to do so. But let's go back to the broader issue of universality and what is the impact of having the big players outside of the system. Well, first of all, we need universality because if the main criteria for establishing the core jurisdiction, I mean, universality of ratification of the Rome Statute, not universality of justice as an ideal, but you know, the largest possible ratification of the statute is necessary because of the territoriality principle. In other words, the more states will accept the jurisdiction of the court, the more territories will be protected by the jurisdiction of the court, the more victims will have access to justice. The main example that I can offer you is Syria. Syria is certainly the place where we had the bloodiest armed conflict in the 21st century. Not as bloody as, you know, the genocide in Rwanda of the 20th century or the repression in Cambodia, where we talk about more than 2 million victims, or you know, World War II, World War I, you name them. Poland, most of you are from Poland, and you know better than me the history of your own country that was the theater of some of the largest massacres that humankind has ever witnessed. So even though we are not witnessing armed conflicts with millions of victims like in the past century, in this century we have witnessed a conflict, the one in Syria, where the number of victims have been assessed in the region of the 100,000, okay, with millions of refugees. Well, the ICC was criticized because it didn't take any case regarding Syria. Wrong criticism. The ICC simply didn't have territorial jurisdiction because Syria was not a state party to the Rome Statute. I met, as soon as I became Secretary General of the Parliamentarians for Global Action, I asked a meeting with the prosecutor of the International Criminal Court. It was the year 2014. And finally, after many months, I managed to meet in New York Prosecutor Bensouda. And in a private meeting, I provided her with a number of requests, pleadings from members of parliaments from the Netherlands, from Iraq, from other regions of the world, where they were stating that given that many members of the group called the Islamic State, so-called Islamic State or ISIS, Daesh, whatever it's called, since so many members of this group were nationals of state parties to the Rome Statute, including some commanders from Tunisia, some prominent leading commanders from Belgium, UK, and so on. Many from the Maldives, another state party that, thanks to the work of the Parliamentarians for Global Action, decided to join the Rome Statute through a campaign led by the Honorable Ahmed Malouf, who was then jailed after the ratification process, then freed, became a minister. Now there is again a repression in Maldives that we are following closely as human rights defenders. But, you know, history is very complicated. So what happened is that we presented this evidence or these sort of statements, statement of facts that may be investigated and become evidence. But the prosecutor responded saying, since I do not have territorial jurisdiction, I cannot look at each and every element of the chain of command. And this blocks me to see also both sides to the conflict, because of course the Assad regime was also involved in the perpetration of mass atrocity crimes, as we know, even larger than the one committed by ISIS or other rebel organizations. So to a certain effect, this has been the policy of the three prosecutors, that they never entered into a case only on the basis of active personality, with one exception, Hamas. When Hamas commandos attacked on the 7th and 8th of October the territories of Israel, they allegedly committed crimes against humanity, including mass murder, rape, torture, and above all, arbitrary imprisonment that led to the hostage taking and the current phenomenon we're still witnessing today, continued crime. Well, they committed the crimes in the territory of a state non-party, Israel. Yet, because they were recognized under international law as nationals of the Palestinian Authority, or as they call themselves, State of Palestine, the court exercised, the prosecutor started investigations, and so far the court jurisprudence is in line with the initial determination that under the United Nations Charter, Palestine would fulfill the criteria of statehood under the law of the United Nations, not under customary international law. So I think with this, but you can also argue that Hamas, this criminal organization, organized the territories of the Gaza Strip to organize, to plan, to prepare. So many conduct that are criminalized under crimes against humanity and war crimes took place in the territories of Palestine too. So you have also the territorial element. And then, of course, when the arbitrary imprisonment as a crime against humanity took place, insofar as the kidnappings framework was, continued, that happened, of course, within the territories of Palestine. So you have both criteria that applied. In any case, so far, 125 states decided to join the Rome Statute system, and by doing so, protecting, first and foremost, their territories from impunity for international crimes. Now, impunity doesn't mean, again, let me tell you, when I speak about the goal of putting an end to impunity, I'm not naive. I don't live in an ivory tower thinking that each and every one that gets indicted before the court and an arrest warrant issued will end up in the Hague, being adjudicated and eventually convicted on or found innocent because the evidence is not available or there are reasonable doubt. But the fight against impunity means, under international law, in my view, at this stage of its development, to bring about clarity in international relations. And understand that there is an inevitability nowadays that if you commit certain conduct, there will be certain consequences. And I'm not saying something that when Judge Mansky invited me to celebrate the 20th anniversary of the entry into force of the statute, this is something that I was not ready to say at that time. That was the 17th of July, 2022. Am I correct, Judge? We were together there and you invited me in the final panel. I would have not said that. And why is that? Because my major element of criticism towards the International Criminal Court, and in particular the Office of the Prosecutor, was the fact that, in my humble view, the Office of the Prosecutor did not act according to the Rome Statute in respect of the situation of Afghanistan, where a certain group, the Taliban, were exercising a policy of widespread and systematic persecution and enslavement of women, girls, and young boys, recruited and enslaved as and manipulated into the Taliban ranks. And this phenomenon didn't start on the 15th of August 2021. It's a phenomenon that we can trace back from the birth of the Taliban, and certainly was one of the reasons why President Hamid Karzai, in February 2003, on a day in which I was in the Russian State Duma in Moscow, I was at that time exercising my role on behalf of Parliamentarians for Global Action, organizing a conference for the so-called parliamentarians from the former CIS member states, or Commonwealth of Independent States, it was called, that sort of ex-Soviet republics entity that was created at that time. And we had parliamentarians from Georgia, the Deputy Speaker of Ukraine, Professor Muziaka, from Armenia, of course, from the Russian Federation, including the chairman of the Foreign Relations Committee, the Deputy Speaker, the representative for foreign affairs, for justice and foreign affairs of President Vladimir Putin in the room, Mr. Palayev, announcing that the president had instructed the Ministry of Justice to work on a law to implement the Rome Statute standards into Russian criminal law. I'm talking about February 2003. All right. Of course, I was not alone. I was together with a member of parliament from my own country of nationality, Italy, Honorable Enrico Nan, from the political party of the Prime Minister of the time, Mr. Berlusconi, and many other and Senator Reinel Andrichuk from Canada, from the Conservative Party, and many other authorities. And I can just give you an anecdote here. These were the last months in office of the government of former President Shevardnadze, who came from the nomenclatura of the Soviet Union, and he had become the president of Georgia. And I arranged a lunch meeting for the parliamentarian representing the government in that conference, as well as the Secretary General of the political party of the opposition who would have won the next elections in Georgia, 2003. And that lunch served to craft a bipartisan amendment to vote in parliament the ratification of the Rome Statute by Georgia, which happened a few months after that conference. Okay, of course, many other actors worked in Georgia, civil society organization, the Young Lawyers Association, the Open Society Institute, many actors contributed to a fantastic process of ratification by that sovereign country that now is in a very difficult situation. So just to tell you how, how universality has been pursued by also creating political prioritization among leaders of political parties that were brought together by my former organization, but also by others, the Coalition for the International Criminal Court, in some cases even the International Committee of the Red Cross. Many actors contributed in many regions. But when on that very day of the end of February 2003, President Karzai issued a media statement saying, notwithstanding the negative advice from our best strategic ally, the United States of America, notwithstanding their negative advice, on behalf of sovereign Afghanistan, today I deposit the instrument of ratification of the Rome Statute at the United Nations, because we have to put an end to impunity for mass atrocity crimes perpetrated against the Afghani people. Enough is enough. Regretfully, no action was taken on that ratification for many years. Only now, after so long, we have finally an announcement by the Office of the Prosecutor that the two of the leaders of the Taliban are under a procedure, a request for an arrest warrant for persecution and hopefully also some other crimes, because as we know, gender persecution is prosecutable before the court, but under Article 7, crimes against humanity definition of the Rome Statute, we have a rather retrogressive provision that requires a link between the crime against humanity of persecution and other crimes falling under the jurisdiction of the court. So I'm sure that the prosecutor has included other incriminations in that document, but since it's not public, we cannot comment on it. So today, in my view, there is clarity regarding the leader of the Taliban and the head of the judiciary of the Taliban, I believe, because they are implementing a criminogenic policy of crimes against humanity directed against essentially a half of their population, as well as, I hope, a lot of young boys who are minors and are indoctrinated into the Taliban ideology and make them become war machine, as if, ready to become child soldiers. But I'm very interested in the enslavement. The crime against humanity of enslavement even predates Nuremberg. It's maybe the first of the crimes against humanity. We go back to the slave trade of the 19th century, where there is somebody exercising property rights over somebody else who is denied the fact of being an individual free to express his or her human rights. So, and to enjoy his or her human rights. So, today, I think we can say that there is clarity on them. There is clarity on the president of the Russian Federation. There is some clarity to a certain extent on the prime minister of the state of Israel. So certainly these facts are not outrageous, as a famous head of state said a few months ago, or they have to be seen as politicization of international justice. They are somehow inevitable consequences of alleged violations of the Rome Statute. And the Rome Statute applies where? On the territories of states that have accepted the jurisdiction of the court under Article 12 of the statute, for good when they ratify, and on specific situations when they accept the jurisdiction under Article 12, paragraph 3. In addition, of course, we know that there is some sort of universal jurisdiction still left in the Rome Statute system, but that one is really politicized because it depends on the positive determination of a qualified majority of member states in the United Nations Security Council, including the concurrence of the 5 permanent members who are able, through their negative vote, to block any referral of a situation to the jurisdiction of the court under Article 12, paragraph B, 13, paragraph B of the Rome Statute. So Article 12 and 13B are the provisions that creates the jurisdiction of the court. And there is no mismatch, there is no asymmetry, there is no element, there is no revolution brought about by the Rome Statute against the sovereignty of state. Why is that? Because it's the very sovereignty of the territorial state that gets breached when a foreigner enters a territory of another country and allegedly commits, until found guilty beyond reasonable doubt, commits these types of atrocity crimes as they are defined under international law, as they were established under the Nuremberg principle, and so on and so forth in all the other instruments until Rome and in the jurisprudence of the court. So this is a court about individuals. It doesn't bind states that are non-parties. So that's really the biggest weakness of the system, which is that the court orders are only binding towards the states that have accepted the jurisdiction of the court or regarding which the Security Council has imposed the jurisdiction of the court against their will under Chapter 7 of the Charter. Because these are crimes, the most serious crimes of concern to the international community as a whole. They shock humankind. They represent a jus cogens violation. They are customary international law breaches. Therefore, the Security Council is not creating new law, not imposing new law on states non-parties, is applying pre-existing law, including the principle of no immunities, as the appeal chambers of the court clearly found in 2019 in the Bashir case regarding the failure of Jordan to arrest the former head of state of Sudan when he was a sitting head of state. So I think universality is the foundation of the system. Cooperation is essential for the system to effectively work, but it only applies to state parties, because treaty law creates, under the Vienna Convention on the Law of Treaties, only states that agreed to be bound by a treaty are to be bound by that treaty. It's a tautological affirmation, but that's the way the system works. It's an horizontal system, not a vertical one where we have a rule of law. We are not yet a rule of international law. We have an aspiration to that principle through the UN Charter and goals of multilateralism that are with us, but we are not yet there. So it's even more important that the largest states join the court. Well, in terms of territory, the second largest state of the world is already a party to the court. Canada is the second largest territory of the world after Russia, Russian Federation. But in terms of population, we are not doing so well. Let me give you some statistics. So based on population, we only, if we take the 20 most populated states of the world, we have only number 6, 7, and 8 in the top 10, namely Nigeria, Brazil, and Bangladesh. And then in the second tier of the top 20, we are doing a little bit better because we have Mexico, Japan, Democratic Republic of the Congo, and Germany. So in total, we have only 7 out of 20 of the most populated countries. In terms of territory, we have 9. So in addition to Canada, which is number 2, we have Brazil, number 5, Australia, number 6, Argentina, number 8, Congo, number 11, DR Congo, number 11. We have very important nowadays, much more important than before. Number 12, we have Denmark/Greenland. very important country nowadays to be protected by the Rome Statute. And number 14, we have Mexico. Number 19, we have the, and I'm sure my Mongolian friends will not be upset because of these language that I use, the country that decided to join the Rome Statute because, as the members of parliament told me, back in the year 2001, before even the entry into force of the statute itself, because they didn't want to be squashed into the sandwich between Russia and China and wanted to be their territory to be further protected, and they did it unanimously. Mongolia unanimously voted for the ratification, as by the way, both chambers of the Japanese parliament did in 2007. And the 20th most largest state is Peru. So we have 9 of the 20 largest territories. We are doing a little bit better if we look at the biggest states, looking at the statistics of the economies, the sizes of the economies, gross national products, where we have some of the largest economies of the world, 13 out of 20, of the top 20 countries. Sorry, Poland is 21, according to the statistics available. So you're out just by one place. But we have number 3, Japan, number 4, Germany, number 6, UK, number 7, France, or they can, depending on the statistics, sometimes France is 6 and UK 7, depending on the value of the pound, whatever. Number 9, Canada. Number 10, Italy. Number 11, Brazil. Number 12, Australia. Number 13, South Korea. 14, Mexico. 15, Spain. 18, Netherlands. And 20, Switzerland. So we are doing much better. So apparently rich states, they love to protect their people from international crimes. Okay, I'm simplifying, of course. I'm oversimplifying and provoking reactions by the audience in a very simplistic way. Needless to say, of course, the United States of America, the largest economy, and the People's Republic of China also want to protect their populations from international crimes. It goes without saying. And we can trace their statements in support of accountability for international crimes since 1998 to today without any fear of being contradicted. Yet what happens is that they view only justice as something acceptable when it is convenient for what they defined national security interest. This led them to adopt a very important resolution in 2011, United Nations Security Council Resolution 1970. Don't forget that, and don't mix it up in 1973. Okay, 1973 was violated. It allowed the use of force by NATO to create a no-fly zone and protect the civilian populations in Libya. It was not done the way it should have been. Instead of just protecting the population, essentially NATO helped the Libyan rebels to get rid of the Gaddafi regime. And that's really unfortunate. And that unfortunately killed the responsibility to protect doctrine and had very negative repercussions in the development of the practice of international law before the Security Council. But 1970 should be safeguarded. What 1970 does, it imposes the jurisdiction of the Rome Statute over Libya. And when it happens, there is unanimity in the Security Council. United States, Russian Federation, under President Putin, already after certain facts had happened already in 2008 in Georgia, as well as, of course, People's Republic of China. India was not part of the Security Council, so we cannot infer how they would have voted. But why is this important? Because it shows that in practice, not in principle, in practice, the Rome Statute reflects customary international law accepted by all. Otherwise, it would have been unlawful to impose on a non-state party its legal standards. Because when the jurisdiction of the court is imposed over a recalcitrant state like the Gaddafi regime at that time, and then again, we had not a very cooperative new government of Libya, now split in two, and we still have a very serious situation under investigation by the Office of the Prosecutor, as allegedly crimes against humanity are still occurring and war crimes are still occurring in Libya. Well, when we have such a determination, that the Rome Statute must apply to the Libyan territories against the will of the sovereign state, it has to be that the Rome Statute reflects customary international law, at least insofar as criminal law is concerned, Part 2 and Part 3 of the statute. Otherwise, the Security Council would act as a legislator, which is not allowed under the UN Charter, because under Article 1 of the Charter, under Chapter 7, every resolution must be in fulfillment of the existing principles of international law. Okay, so even the People's Republic of China delegation that now is challenging the definition of Article 7 in the negotiations towards a treaty for crimes against humanity at the UN, to outlaw, to prevent and repress crimes against humanity, even though they are doubting about some elements of the definition today, at that time, they didn't object. And in fact, in Rome, when the definition of the crimes were adopted, there was unanimity in the Committee of the Whole. It's only because the United States is against active personality jurisdiction that there is a vote on the Rome Statute. Article 12, the position of the United States was that instead of or, it should have been an and in Article 12. So we would have needed both the acceptance by the state of territory and the state of nationality before an automatic jurisdiction of the court would have existed under Article 12 and Article 15 proprio motu, or 13A state referral. All right? Don't mix up the trigger mechanism with the establishment of the jurisdiction. The jurisdiction is based on state consent insofar as ratification or acceptance is concerned. But that was not acceptable because there was a South Korean proposal that had 4 alternative criteria for the establishment of the court automatic jurisdiction, namely territory, active personality, or passive personality, or custodial state, like in the torture convention, the state that detains fugitives that who travels. That was too progressive. Of course, Germany, remember, didn't want any Article 12. The position of Germany in March 1998 at the PrepCom in New York was we didn't need preconditions for the establishment of the court jurisdiction under Article 12. So Article 12 was unnecessary because the court should have been a court of universal jurisdiction, competent on any international crimes anywhere in the world, because it would apply international law, international criminal law, on behalf of the international community as a whole, because the law of the Rome Statute reflects customary law since Nuremberg. Otherwise, Nuremberg would have been unlawful itself. But the majority of the states was not ready for such a progressive understanding of jurisdiction. So the compromise was, thanks to the UK mediation, was found in the alternative criteria of either territory or active personality. But as I told you at the beginning of this seminar, essentially all the jurisprudence of the court is based on territoriality. Okay. So the resolution 1970 is not only important because it expands the jurisdiction of the court over a recalcitrant state, Libya, but also because it is the reflection of the position of the permanent members. Now, of course, in practice, we can say this. In principle, we cannot, because the same permanent members abstained, some of them abstained on the referral of the situation in Darfur, Sudan in 2005, resolution 1593, if I'm not mistaken. And then onwards decided to not refer anymore any situation to the jurisdiction of the court for political reasons. So in other words, we as international criminal lawyers should maybe here wear the hat of public international lawyers who do not live in an ivory tower. We are not separated from international relations because we live in a very primitive system based on the expression of state sovereignty, state-driven international law that is still ruling the system, unfortunately, but that's the reality that we need to photograph. And what we can observe is that while from a legal standard point of view, the ICC is the centerpiece of the international criminal justice system, since now it has become an independent, impartial, and effective court, it is now the subject of retaliation or selective approaches by the permanent members, but also by some regional powers, but also, as Professor, in this case, I call you Professor, Judge of Mansky, Professor Mansky told us, also some state parties, that when they don't like something, they stop cooperating with the court, as it happened recently, unfortunately, in a prominent case in my own country of nationality. So it is a very complex reality we are facing, and there is an enormous amount of work to be done to explain the strength and the weaknesses of the system. Okay, to finish my presentation, let's go to the P3+1 positions. I think I already highlighted why the United States voted against in Rome. Yet the United States signed the Rome Statute under the Clinton administration, and under the Bush administration already took advantage of Article 18, paragraph 1 of the Vienna Convention to point out that to the Secretariat of the United Nations, the Secretary General, who is the depositor of the treaty, that it does not intend to ratify the treaty and is not bound by the moral or political obligation not to defeat the object and purpose of the statute under Article 18. Russia did the same, but it took 14 extra years to do so. Russia did it in 2016 in the face of the developments relating to the situation in Georgia and South Ossetia and so on. Russia voted, so the United States position developed into something that was deemed to be workable under both the Obama and the Biden administration. Under Trump, it had a U-turn, a very strange U-turn towards the end of the presidency, where a certain policy that had been elaborated by John Bolton, who had been national security advisor, but the policy was actually implemented after that he had been fired from the position, and he had become a millionaire, writing a book against President Trump under the first presidency. So quite a schizophrenic phenomenon that the main enemy of the court policies become actual, with sanctions against former prosecutor Bensouda, the moment in which the person who conceived them became an opponent to the head of the administration. But, you know, that's the schizophrenic reality in which we live. And the argument was at that time, and we are confronted with the same argument today, that through an executive order, a national emergency was declared on account of some purported investigation and prosecutions relating to US nationals or individuals of that are nationals of US strategic allies like Israel. So in other words, this executive order is based on a finding that there is a national emergency in the United States due to this work done by the prosecutor and the judges at the pretrial level in The Hague. And this is quite shocking. I don't see that emergency anywhere, neither in the United States nor elsewhere. So in other words, thinking that an arrest warrant is a game changer in terms of national security is a big mistake. It doesn't bring about any emergency situation, all right? Because the Rome Statute is not binding on these so-called state of nationalities of the individuals concerned by the arrest warrants, and because of a number of other restrictions that the Rome Statute system, whether we like it or not, entails, because it's based on the sovereign will of states who are the enforcers of the court orders. In a asymmetric system in which judges are individuals, the prosecutor is an individual, the victims are individuals, the perpetrator is an individual, regardless of status. Can be an head of state and so on and so forth. But for the court, what counts is that the perpetrator is only an individual. So we are not at all infringing upon state prerogatives. What we are doing, in my humble view, we are bringing about clarity in international relations as a consequence of the application of international law, represented by the Rome Statute, which is, if you commit a crime against humanity in this day and age, in 2025, it's not like back in the 90s, where you could do the genocide in Rwanda, you could order the Srebrenica massacres. Well, at that time, there was an ICTY ongoing, so I'm mistaken on that one. Or back in the 70s, when Pol Pot could create the killing fields. These things are not possible anymore with impunity, because if there is the jurisdiction of the court, an arrest warrant will be inevitable for you if the court applies the statute, if the organs of the court apply the statute. Okay? And probably this is the single biggest mistake done, in my humble view, by the court system itself. It was not able to explain this inevitability of the course of justice. It was not every day in the media engaging the general public. There was, for example, an interview by the prosecutor with the CNN in the famous day of the announcement of the arrest warrants relating to the situation in Palestine, but we haven't seen an engagement of the court as a whole, as an international organization, on an everyday basis with the global media and the global public. If you don't do that, you become irrelevant. If you don't do that, you lose traction. If you don't do that, some states may believe that you can be shut down. All right, I worked with members of parliaments worldwide, and they believed in what I was saying about the International Criminal Court. And my main duty was to always tell the truth insofar as I considered it. And we cannot be naive that things happen because they are right. This is not the world in which we live. Every single achievement is the result of very hard work and struggle. So that's the missing element of the Rome Statute system. We don't have sort of a strategic unit on behalf of the state parties, on behalf of the organs of the court, with separated mandates, of course, explaining to the global public opinion that, yes, you cannot kidnap children who are in a family or in an orphanatrophy or in an institute in the occupied territories of Ukraine and Russify them, make them make them somebody else whom they are not. That's not only a violation of the Geneva Convention, international humanitarian law, and so on and so forth. It's a crime against humanity. So, that's an educational job that has to be done on an everyday basis. And, when I heard you speaking, Mr. President, I said, fantastic. That's the way it has to be. But of course, the structure should have been prepared to also handle these global circus of strategic communication. And the biggest defeat, if I can use that term, of the court has been when, after the very, very violent outcomes of the Kenyan elections, there were a number of investigations and prosecutions, and they all succumbed due to a number of factors, including the fact that the individuals were accused were allowed to go back home and do a number of things that probably created an environment that was totally unsafe for anyone to testify against them, and a number of other factors that have never been proven. So I'm doing a hypothesis, and ultimately there was not even evidence sufficient to bring them to trial, or the trial had to be dismissed, and so on and so forth. So the charges were vacated. So, and this is the way law works. Many people who are accused will be found not guilty, or the evidence will prove insufficient. That's part of life. But I think that the court has always operated in an environment as if it was a criminal court, whereby it was to be, whereby the court should have had a better understanding that it was an international court before being a criminal court to survive. So I still believe that the Rome Statute project is so strong, the force of the law is so strong that it will prevail against what the new wave of sanctions, for example, that may derive from the United States, which are, by the way, in my humble view, counterproductive, because these types of measures, instead of weakening the resolve of those working in and in support of the institutions, are doubling the good intentions, are doubling the aspirations to make a difference by those serving the court and those supporting the court. So ultimately, this type of measures that are totally ultronous to what the law should be, sanctions regimes, these targeted sanctions are born to deal with human rights violators, to deal with international terrorism and other gross abuses, not to deal with an institutional framework where you have judges, prosecutors, and court officials who apply the law and are bound solely by the law, and they don't foresee and produce and implement any political agenda. That has to be absolutely clear, that while the International Criminal Court might have made many mistakes, might have been criticized on many grounds, none of the decisions that the court has taken so far has been politically motivated, never. And I think the majority of the American public agrees with this. So this is really a retrograde fight. But we have seen it, how certain leaders progress in their understanding of the situation. And I think I want to be optimistic, and I think there is a room for improving this situation. Now, going to the position of the People's Republic of China, at the end of the day, the People's Republic of China expressed a skeptical view on the principle of complementarity in Rome. Their position was that if there is a challenge to the court's jurisdiction done by a national jurisdiction, the last word should be with the state in question, so with the Supreme Court of China, and not with the court itself in The Hague. You understand that this would have nullified the internationality of the court. It would have created a Chinese court under the Supreme Court, an Italian court under the Corte di Cassazione, or whatever. The International Criminal Court would have been subjugated to the jurisdiction of each and every Supreme Court of each and every member state. It could have not worked, complementarity, under these predicates. So this excessive attachment by the People's Republic of China to a notion of sovereignty that is really the one that we had in the 19th century, led the People's Republic of China not anymore to repeat this argument. So we can trace in the practice of the UN that their statements have been mitigated towards criticism on the court, and whereby they still believe that they have a number of objections towards the regime imposed by the court. As I told you, Resolution 1970 also saw their positive vote on the Libya situation, and the future will tell us how things will develop. Finally, India. Now, the Indian position is very interesting because it is dictated by an aspiration to implement and support international law, even though in the last years the situation worsened. So in Rome, the statement of the Indian delegation to justify abstention, not a negative vote, was that in the view of India, it was not correct to include in the Rome Statute an element of Security Council referral and deferral. As the criticism voiced by India was that the Security Council was expressing a political organ operation that would have interfered unduly with the independent operations of the court. And so in a way, even though then there are other smaller objections that can be traced in those statements, in a way you can say that the position of India was a principled one in Rome. And in the famous year 2003, I'm always mentioning 2003, just a couple of months, a month and a half after Moscow, I was in Delhi trying to organize a South Asian conference on the ratification and implementation of the Rome Statute with prominent members of parliament, with one of our leading members from Germany having had a bilateral with the leader of the Congress Party in preparation, and we had access to the Attorney General of the BJP party, the same party that today is in government, and a number of other talks that indicated that there was a lot of willingness in India to engage on the ICC. And let me tell you something, 20 years after the time, I can share these private conversations. I'm not going to breach any confidentiality. In a meeting a few days before this event, which never took place because it was not authorized, I was told that while the Ministry of External Affairs and the Ministry of Justice, Attorney General Office, had given positive advice towards starting the process to ratify the statute, having therefore Parliament sooner or later involved, it was the Ministry of Interior that vetoed the decision on account of the fact that the country had to deal with internal problems like terrorism or other serious matters, and membership in the Rome Statute could have been seen as an element of constraint. Again, in a very cautious and legal wording, this was the message that was conveyed to me. And so there was still a room for discussion, all right? Things changed totally after that weekend, because that weekend of March 2003, something happened in Gujarat, a major massacre in a village populated mostly by Muslims, who were burned alive and the police was watching. And this led to a number of grievances and complaints. And one of the persons that was accused of being implicated in this massacre is an individual who is currently the leader of that very powerful nation. So essentially, since the current prime minister is in charge, we have seen really another line towards international justice, and crimes against humanity became really a taboo for Indian foreign policy, to the point that an Indian delegate stated that essentially international jurisdiction shouldn't exist, and only domestic jurisdictions should deal with this type of offenses against humanity. So unfortunately, there we had a very serious retrogression. Again, India is a democracy. We need to be hopeful. There is a vibrant civil society. There are universities like Jindal that are regularly organizing the highest possible level summits with scholars from all over the world. And the public opinion of India is vibrant. And most likely even the prime minister realized that things have changed vis-a-vis what could have happened in the past. So I'm also optimistic there. But yes, in terms of universality, the entire South America is covered by the Rome Statute. Most of Latin America is with the Caribbeans. Most of North America is with Canada and Mexico, with the exception of the US. Most of Europe is covered by the Rome Statute, even more now that Ukraine joined, which is a large territory. The majority of African states joined the Rome Statute, even though the biggest territories are out, in North Africa and the Horn of Africa, troubled places like Somalia are out of the system and so on. But the problem is that in Asia, we have a minority of states. Most of Asia is outside of the system. So there is an enormous amount of work to be done there, as well as, of course, in the Middle East, which is mostly part of Asia, as well as North Africa. So Middle East and North Africa and Asia as such are the less represented areas of the world. A lot of work to be done by jurists, by think tanks like the Krakow Center, by NGOs like Sunflowers, and I really applaud the partnership with the International Center for Multi-Generational Legacies of Trauma, which is an NGO in which I serve as the advisory counselor, co-chairing the justice component. And there is an enormous work to be done to give the voice to the victims of international crimes, who have no nationality. They are first and foremost individuals who are suffering because they've been deprived of their most fundamental human rights. And there is a responsibility for every sovereign state to protect them. That's what we call sovereignty nowadays. It's not anymore in the interest of an abstract entity called the state. It must be in the interest of the individuals living and populating that state. That's what I call national security of a state. It's a national framework protecting each of us from bad things happening to us, including the most serious crimes. So, and national and international security must be understood in the lenses of the rights of individuals, all of us, especially the victims who are personally affected and are suffering, not in abstracto, but in concreto every day because of these atrocious acts done in the names of wars of aggression, genocides, crimes against humanity, and or war crimes. So I think I've covered a lot of issues, not all, but I think the flow was there, and I look forward to respond to a few questions.
Thank you very much for sharing your thoughts with us, and I believe that they certainly have given us a lot to think about. And I already see a first voice in the discussion, Professor Paweł Wiliński, please.
Yes, thank you. Can you hear me?
Yes, we can hear you very well.
Firstly, I would like to say thank you, David, for this totally rich presentation with lots of issues showing how deep is your experience and knowledge about the universality. And I agree with Piotr that we probably can't find anyone who have a richer experience in this field. However, your presentation is like presenting universality as a living instrument. That's great, because that shows the essence of the problem. And the essence of the problem, that is understanding universality as something against independence. For many states that are against, I believe it is something that they don't understand, that universality is not an instrument that is against independence. However, most of the countries through centuries created their own state on this, I would say, statical way of thinking about the independence. If we look through around the world for among the countries that we have problem with the independence, we see that we have the strongest countries, the biggest players, and the smallest one. The strongest, they don't care about universality, and the smallest, they don't dare to join if they are neighbors of those bigger. And that's the problem. The understanding of your presentation was also for me to see what is an impact of two first tribunals. Comparing the tribunal in the Nuremberg against tribunal in Tokyo. When we think about universality, we can see that what we learned from the Nuremberg, Europe, and American countries was a lesson that universality is an instrument that supports all of us and can let us create a system of international justice. It's not the same when we see for the heritage of the Tokyo trial, a trial that was not an international cooperation system effect, but was just MacArthur decisions, totally against the tradition and culture of this continent. And that's why probably it was, in fact, deeply rejected. So when we base today's universality on what we achieved in the Statute of the Military Tribunal and understanding that the universality is also protection, they don't have this feeling. And maybe this is one of the reasons why they don't see this as something strong. And another idea that came to my mind is that when you spoke about the India is an excellent example. Universality is an instrument that we have to cover territory before the conflict. During the conflict, in joining, inviting the country to the system is very difficult. Ukraine is trying to do that, but we see how difficult it is. I believe that the conflict, the not finished conflict, have so strong effect on the country and neighboring countries that usually it is impossible to discuss with them really deeply about the universality and joining the system. And the last sentence that I want to say is understanding, thanks to your presentation, the strength of universality as a concept. I thought that rejection of universality should be recognized maybe as a serious step towards accepting situations leading to serious violations of human rights. We don't treat that. We say, okay, country have a right not to join us. But of course they protect human rights. But maybe this is one of the signals that should be on the base of the international laws, straight understood as a step against protection of this concept in maybe in the long or short perspective. It does, I don't know. I would be grateful if you could comment on that at least a bit. Thank you.
Should I start, or Professor Ovmansky wants to say something maybe before me?
Yes, that's a good question. Professor Hofmański, I don't know if you want to add something to what Professor Wieliński said, or maybe we'll wait
No, I basically, of course, I would comment, but I would ask basically many questions to David, but I have to choose some of them. But I think for the clarity, it would be better if David start to answer. And then if you allowed, Sonia, I would take floor to raise another issues.
Okay, perfect.
Let me start by saying that maybe I disagree slightly only with one point. And of course, I know, Professor Wieliński, you are a member of the Supreme Court, correct? So I'm under your jurisdiction here. You can take over what I say. But let me say, I don't think that the strongest states, the strongest power, don't care. In other words, you are right that they don't care to ratify, but they care not to be, they care for their leaders and their officials and their nationals not to fall under the jurisdiction of the court. Why they do so? Because they feel that they may be found in violation of international law, and international law is still the rule of the game. Okay, it's still something that they want to invoke to protect their interests. It's in their interest if international law is respected. So certainly, I have not seen yet evidence of this in the ongoing negotiations, but certainly this is the ICC arrest warrant in each situation that is dealt with for peace deals is a huge issue. And you know what? Wonderful. That's great. So it's more difficult to be unfair and unjust. So if they do something very bad, everybody will know, oh my God, they are trying to give an amnesty to this type of conduct. It will be a scandal. Clarity, communication. We live in a world where, you know, we know the way it works. We are not searching for perfect justice. Now, the problem that you highlight vis-a-vis post-World War II situations, as well as the during armed conflict acceptance, I relate it to another concept, Judge, which is the concept of victor's justice. Some colleagues from the US recently wrote in a blog that essentially, well, it's too early for all of us to accept what the court is doing in The Hague. What we are amenable to is victor's justice, like in Nuremberg. If somebody very bad happens and is committed by the losers, let's use the justice element to a better transition, not to transition a society into a democracy like we did it in Europe, no, with Germany with Italy to a lesser extent, because we had less accountability for World War II crimes. And also, I mean, also Japan, to a certain extent, the Japanese society certainly contested some elements of the Tokyo Tribunal, as you said, this unilateral establishment by by the commander-in-chief on the Far East, instead of a treaty like the London Agreement. No, it was a better way. But at the end of the day, even though they criticized it, they lived with the outcomes. All right, they didn't recreate the same empire or army that existed before World War II and during the war in Manchuria and all the other imperialistic violations of international law committed by Japan. So I think, but I think that's our challenge, that states who are law-abiding nations, we, the peoples and the members of the United Nations, the law-abiding nations, we believe in the principles of law and justice, not after the facts, but before the facts. Like criminal law applies ex ante facto, nullum crimen sine lege. So that's the law, that's the legality, that's the civilization we know. Can we only apply the law after the facts to the losers? No, not anymore. Not anymore. All right. And this explains what happened that created so much controversy in the US relating to the Prime Minister of the State of Israel. That's the explanation is there. He's certainly the victor, but was the modality of the conduct of the hostilities in line with international humanitarian law and international criminal law? The prosecutor of the court believes not. The pretrial chamber issued an arrest warrant. He has the right to defend himself before a court of law. That's the way it works. It has to be explained every day to all the foreign ministers, the prime minister, the presidents. So we have a lot of work to be done. Otherwise, okay, the fallback, victor's justice, only for those who lose. But that's not what we need today. At least not for us. I am, of course, I'm connected here from Rome. I work in the US. But this is the beautiness, the added value of international organizations like the European Union, which are based on the sovereign equality of states and on the respect of the fundamental rights of all individuals in the territories of the Union, including foreign nationals, not only Italians, Polish, German, and French and Spanish, but also everyone. The rights are for the individual, all right? Whether they are legal or illegal, they are all individuals bearing fundamental rights to be respected everywhere. And yes, this is strengthening, in my view, sovereignty of state and independence of states and legitimacy of states. For some leaders or some political parties, that's not the case. In my view, they are wrong. So we need to prevail. It's a democratic game that needs to be won in our free societies, hoping that one day also other societies that are still closed, like, for example, the society in the People's Republic of China, in the United Arab Emirates, or in Ethiopia, that will open up and people will be able to say that they disagree with a leader and they can provide for alternatives. Today, that's not the case in these countries. So I think, but this is an aspiration towards a certain model that can vary depending on the sensitivities of the populations, of cultures, of, it may vary, but that instinct to be free from oppression, slavery, colonization exists everywhere. So I think, I think we need to really get rid of the victor's justice complex. I think in the European Union, we have achieved that. I think also almost all the states that ratified the statute did it in affirmation of that principle, that justice is equal for all, or that all individuals are equal before the law. But some individuals, they still believe that some of them themselves, maybe they are more equal than others. That's the problem we have. That's the way I will look at the problem that we have. I'm not saying anything new. Professor Otto Trifterer was saying it so eloquently, and he was our master in Salzburg. And it's not a case that his commentary on the Rome Statute is the most cited in the world. Now he's of course taken over by Professor Ambos, but that's the ideal. That is the meta-juridical concept upon which we build our rule of law that we would like to see also globally. We are not yet there. It's still a fight regarding which we have to prevail. But we need to stay firm in our positions and continue to strive for universality of these values.
Thank you very much. And Professor Hofmański, please.
Yeah, thank you. Thank you, David. First of all, the fantastic was not the introduction to the discussion, it was the whole fantastic lecture. Thank you very much for it. So I managed to reduce the list of my questions to two, basically. The first one is linked to the issue of the productiveness of the sanction you mentioned. I would agree with you that we shouldn't call them sanctions. Sanctions are against the criminals, sanctions against the criminal organization, not against such an entity as a court of law. So I would prefer to say the illegal measures. So I would be happy to see these measures counterproductive. I'm sure they will not influence the activity of the court. They will not influence the decision of judges. Judges, as I always say, are fully aware of the consequences, political consequences of what they are doing, but these consequences will never impact their decisions. But there's always but. So I would ask you, what arguments you would use in respect to the state parties that refuse to cooperate with the court under the political pressure of big non-state parties? I'm thinking here about the Mongolia, which failed to arrest Mr. Putin during his visit in Mongolia. I'm also thinking about the declaration of the Polish government, which publicly declared that Poland will not arrest Mr. Netanyahu during his visit in Poland. Do you think it is not a result of the so-called sanctions against the court? And another issue, completely different issue, mentioned by you during your presentation, is linked to the triggering mechanisms and the role of the Security Council. As you well know, it was one of the points of this discussion in Rome, the issue of the universal jurisdiction of the courts. Because of the opposition of many countries, it was, at the end of the day, replaced basically by the concept of the Security Council referral. The argument was, why we need the universal jurisdiction? If something happened, the always Security Council has the power to refer the situation to the court. And I think it is the big disappointment. Because, of course, we have two referrals mentioned by you in Libya. We have the referral from Sudan. But after these two referrals, the political, the big powers with the veto rights, with the Security Council, never agreed to refer another case. So we see the result. The victims of horrible crimes in Syria and North Korea will never enjoy justice because there's no chance to the political agreement with respect to this issue. So, and that's the question. Do you think that is the time to return to discussion of the universal jurisdiction of the court? I don't think it's against the Vienna Convention about the treaty. Because if many countries, which is internationally recognized, have the universal jurisdiction within national universal jurisdiction against the perpetrators of international crimes, then of course these countries can share this jurisdiction with the court, like they share their own jurisdiction with respect to the other crimes. So I know that is politically unrealistic to think that we can return to the discussion and to achieve this result we want. But yeah, we are free to to discuss this issue. I think I would be happy to hear you.
Yes,
yeah.
And let me say something. Yeah, thank you, Professor. And here we are exercising academic freedom. That's very important for us, and that's why we have academia. That we can say freely whatever we want, respecting everyone. But you know, it's. So let me, start with the second question, which is easier. The first one is very difficult. If I had an answer, I would win a Nobel Prize. But the second question is more technical, and I think I can answer. Listen, I think you have always to look at the rationale of a norm. Why the majority of the states agreed to have Article 13b in the Rome Statute? Why? Because ad hocism had to be avoided. Ad hoc tribunals, not good for the rule of law. Ex post facto on a specific case or situation, provided that there was a lobby, Security Council, 9 states voting, no Security Council permanent members vetoing. No, we don't want to create tribunal after tribunal. Rwanda, and then we had Yugoslavia. Why not Burundi in 1996? So, or Congo 1998. So states were saying, we need, since in any case, it's a fact of life. Now it happened with Yugoslavia and Rwanda. We have the possibility of the Security Council to create ad hoc tribunals. This is a wrong way to proceed. That's not the way the rule of law works, especially for the most serious crimes of concern to the international community as a whole. You cannot be selective. Let's create a permanent court, potentially universally for every possible case. And let's allow the Security Council, if they wish, to refer a situation, so that they don't have to create an ad hoc tribunal. That's the rationale of Article 13b, and it's still there. And that's why when the aggression against Ukraine took place, the fully fledged one, I mean the very evident one, it was really so disappointing that the Kampala Amendment had so much restricted the jurisdiction of the court, not aligning it to Article 12. And so the acceptance of the jurisdiction of Ukraine vis-a-vis the court that took place years earlier, in 2015, could not be used to catch the most serious crime, in my view, as a public international lawyer. I have no doubt that's the most serious crime committed in this continent today, every day, the crime of aggression. I mean, it's incredible that in the year 2022 and so on, we have the crime of aggression ongoing. Of course, it had happened already in the past. We had seen it in Iraq in 2003. We had seen it in a few, when the Soviet Union toppled the Afghanistan government in 1980. So we had seen some war of aggressions after World War II, but they were never wars of annexation like World War II. As the president of the Italian Republic, Professor Sergio Mattarella, stated when he was conferred with the honoris causa doctorate at the University of Marseille 2 weeks ago, he clearly established that what happened on the territories of Ukraine is based on the same premises of what had happened during World War II, wars of annexation. So such a very serious crime is not punishable before the ICC. Why? Because states in Kampala created an exemption that does not belong there. So that's why we have now a very important appointment. I hope that Poland will be an actor, a protagonist, that the Supreme Court might direct a position to the executive to be in New York on the 7th to the 9th of July to really modify the jurisdiction on the crime of aggression, at least to ensure that those territories of the state parties will be protected by non-party aggressors and also by those who make aggressions from within the system, of course, which I think it's not foreseeable. So that's for the Security Council. Now, reopening a negotiation to amend the statute on universal jurisdiction. Maybe I'm a very progressive lawyer, but I think the best service to being progressive is to be realistic, and I think states can apply universal jurisdiction also because states, in their sovereign relations with other states, they have other limits. So they cannot do what the court can do, and of course I'm referring to the issue of personal immunities and other issues. So I think maybe not yet. One day, yes. I mean, yes, when we are ready to not to have any more borders and people will be free to go wherever they want in their life, and we are ready for a world government, 100%. But we are not yet ready to that. We're not yet ready to that massive reform that would entail a revolutionary approach to sovereignty. And then, of course, final point, legalistic, but we are lawyers, correct? Article 121, paragraph 4. Even if we get the amendment to Article 12 and we get rid of it, so no precondition for the exercise of jurisdiction, then we need an entry into force after 7-8 ratifications, which means 113 states must ratify such an amendment. Are 113 state parties ready to do that? I'm not sure. I'm not sure. Not yet. Not yet. Certainly not Hungary, your neighboring country. So we and I stand to be, you know, I stand to be. I would love to be wrong. I would love to be wrong. Now, regarding the sanctions, yes, they are not to be called like that. You're totally right. They are illegal restrictive measures, unilateral and illegal restrictive measures. Of course, they are called sanctions in the US law, and unfortunately, we have to deal with that with that name in that jurisdiction. There is no other way than to challenge them. And of course, I'm sure there will be teams of lawyers ready to take action. Now, I think that position of the United States, as well as other positions, have influenced the current non-cooperation. But I would really treat the Mongolia situation as very different from all the others. The Mongolia situation is unique because we are looking at a state that is really depending for a number of reasons to entertain decent relations with its big neighbors. I would say that in the negotiations, of course, there is non-cooperation, there is a finding, and now there has to be, under the toolbox at the disposal of the president of the Assembly of State Parties, there has to be diplomatic good offices and diplomatic consultations, exchanges of views with a resolution of this situation. But if I was in the Mongolian side, I would invoke some sort of force majeure or state of necessity. In other words, how can Mongolia resist such, you know, the presence of such a neighbor? That, you know, that can also be somehow put together and, you know, put alongside a statement of intent by Mongolia to cooperate fully with the court on any matter that would not put at risk its very survival as an independent nation. So you know, that's what state of necessity means. It means that you are at risk of continuity in terms of your statehood. And honestly, that case as of today can be made. So let's see what happens there. But you know, I don't foresee for Mongolia a reprimanda, in my view. That's not going to be the outcome of the situation. And I know this is not ideal. I said it already. We are not yet living in an international rule of law. I know that. And the judges are doing their job, and the prosecutor is continuing to do his job, and their contribution is that of clarity. Everyone knows in the world, and I don't know if you have watched yesterday's joint press conference by the Prime Minister of the United Kingdom and the President of the United States, but the Prime Minister of the United Kingdom was very clear about the way he views what has happened in respect of Ukraine and recalling what his views are on the president of the Russian Federation. So, and you know, that might have been a weekend if we would have not had the arrest warrant there. So it's important. What the warrant means is still very important, and at the end of the day, you know, no one will be president for life, or if they don't live anymore, those individuals will be remembered also as being the first head of state of a permanent member of the Security Council that was under an international arrest warrant, which is already an important element to break the cycle of impunity for these massive crimes. And the next president will be hopefully more cautious and respectful of international law. So and of course, unfortunately, other cases, scenarios of promised non-cooperation due to these prevailing political understanding or national security definitions that states are giving are very serious. And what we can be happy of is that the current status quo means that unfettered ability to exercise diplomatic relations and travel for certain leaders who are under arrest warrants is not anymore there. That there is an enormous work to be done by their defense lawyers every day. There is a defense lawyer advising them of what to do next. So we have the ICC intervention has already altered to a certain extent certain dynamics. Not to the point where we are preventing the crimes, not yet. That will come hopefully one day when there will be an understanding that there will be an implementation of the measures ordered by the court. We are not yet there. So we need to know the problems to work on solutions. So as I said in my presentation, what I can only say today would be for the court and those who are supporting it and the state parties and the assembly and so on, to speak clearly, publicly, on a daily basis with those who are forming the public opinions worldwide, without any fear to make their hands dirty in the global debate. There is no other way than to talk for being listened. So unfortunately, I see no, there is no shortcut from the hard way of winning the hearts and minds of those who have the ability to take decisions that may be utterly negative for international justice and the rule of international law that we would like to prevail one day.
Thank you very much. And I can see one more question from our audience, from Mr. John Cabon, if I'm correct. Hello.
Yes, hello. Hello. I'm John Cabon. I'm a lawyer from the UK. Thank you very much, Professor Cattin, for a fascinating presentation and the answers you've given to questions. I've got a rather marginal issue to raise, but I'm doing it because I recognize that you've got a lot of experience in dealing with governments in trying to promote the notion of universality and the International Criminal Court. And it really concerns the impartiality of the judgments of the ICC. I've always been struck by the extreme difficulty that courts have in being impartial in domestic jurisdictions when it comes to war crimes. And this applies to countries that have a reputation for having high standards of justice. Countries also that are parties to the Rome Statute. There's an extreme reluctance to convict people who have been on your side in an armed conflict, and a tendency to victimize those who were on the other side. And this is detectable so widely. And but on the other hand, at the International Criminal Court and the hybrid tribunals, it's easy for the judges to be impartial. They come from all over the world. They don't have a dog in the fight, so to speak. So I'm just wondering whether, perhaps I'm being optimistic here, but I'm just wondering whether that strong point of the International Criminal Court, in my opinion, the fact that it is easy, well, easy is perhaps the wrong word, that it is possible for them to achieve a level of impartiality that's difficult in domestic jurisdictions, whether that has been, in your experience, something that's been seen as an advantage of becoming a party, something that's encouraged people to support the International Criminal Court and thereby to support universality. Thank you very much.
You are absolutely right. You are covering an issue that I should have. You're totally right. This is a key added value. It's really the added value of international jurisdictions, that they are distanced enough from the situation in question to provide, in terms of perception of impartiality, a higher ground than domestic courts that are so close to the quarrels, to the fights, to one side or the other, as well as they, that's what used to happen in the Middle Age here in Italy. No, we had the city-states, and if you were in Siena, you would call a judge from Florence to have an impartial judge, because nobody in Siena could be your judge. An impartial is a foreigner, and the judge is the foreigner, because the foreigner has no conflict of interest. He's neither your friend nor your enemy. And so the idea of having these judges who are individuals, who are not anymore Polish, Botswanian or Germans or Italians or Korean or Argentinians, but they are international and they have an international status quo. They are organs, they are individual organs of international justice under international law. Like the Secretary General of the UN is an individual organ. Mr. Guterres is not a Portuguese man. He has his own passport. He represents the organization. Every judge represents the organization as a whole, which applies a law that is common to the international community as a whole. So this brings me, so you are totally right, this is a major selling point for the universality. That's the reason why in Côte d'Ivoire, they ratified the Rome Statute, because they realized nobody would have adjudicated their own people because they were so polarized. Either were pro or anti-Gbagbo, you are pro or anti-Ivory, you are pro or anti-Ouattara, and it was so like the society divided into two. Nobody in Côte d'Ivoire could have brought to justice anyone. It didn't work at the court too. I liked a lot the minority position of the Dominican judge. I don't remember her name now, sorry for that. Just she represented the entire international community, not the Dominican Republic, but she gave a minority opinion. There is something that has been happening at the court that has not really fully understood. So many early dismissals of cases before even trial started that, I, as a poor public international lawyer who was not so skilled in criminal procedure, I felt like certain judges were just acquitting everyone before even the court cases started, or when they had the opportunity, they did it even in appeals. And that's so frustrating when other judges who gave other opinions seem to be much more forceful. So you see, I see the limits of that impartiality that somehow goes to the extreme. At the ICC, we have more acquittals than convictions. It's contrary to the precedents of other tribunals. But anyway, this maybe is even a counterproof. They're even more impartial, or maybe not. We will see. I'm not in a position to say. But let me say, what the reasoning that you make brings me to is to say that we are a bit hypocritical, because we always say the ICC in The Hague is the court of last resort because of the principle of complementarity. Yes, it is, because if states do not fail, the court doesn't intervene. That's clear. But let's be honest. How can states succeed if they are in the middle of a war or a major massacres and so on? So in other words, the reality is different. The reality is that this is the court. This is, as some victims have said in a famous survey that the court or some NGOs, I believe it was the Redress Trust, produced, that victims said, the ICC is our only hope. This was said by several victims in several situations. The ICC is our only hope to see justice done. So, you know, if you're a politician, you want to be elected in your constituency, and you are in the border with Somalia, and you are in northern Kenya, and Al-Shabaab or other groups are coming in and out and are raping women, kidnapping boys, and so on, and you say Kenya must ratify the Rome Statute, and that's why they ratified, because he went and lobbied his own colleagues, because his constituents wanted to be protected by an ICC. That's the reason why Kenya joined under the leadership of former Senator David Muzila, member of the Parliamentarians for Global Action and chair of the PGA chapter in Kenya, who was then, you know, not treated so well when the cases were disclosed, and certain big names like the former, at that time, Deputy Prime Minister Kenyatta was, you know, included in the so-called Ocampo 6 at that time. So these politicians have paid a price for being principled and trying to seek for this impartiality, these impartial judgments that only a free court can give to their constituents, victims of. I also worked, let me finish with something very positive. I worked with so many politicians who themselves had been victims of crimes against humanity. Let me remember here Felipe Michelini, whose father was killed by the Plan Condor in Uruguay, the first political leader assassinated by a plan to bring dictatorships all over Latin America. Let me remember Minú Tavares Mirabal, who was the chairwoman of the Dominican Republic PGA group to get Dominican Republic to ratify since 2004, whose mother and father and aunts were all killed by the Trujillo dictatorship during the brutal repression during the dictatorship. So others from Chile, from other countries I can mention, there is one member of parliament in a village nearby the Bangui airport who told me, David, I will always be re-elected. I said, why? Yeah, I tell you why. Because when the MLC came, the troops of Jean-Pierre Bemba, I took a gun that I had. I went at the door of my village. I showed my gun to the MLC group. It was a village nearby the Bangui airport. And I said, you want to rape, kill, loot as you've done in the other villages? Before doing it, you have to pass over my body, and I'm going to kill you, 5 or 10 of you, before you enter the village. You know what this group did? The MLC, headed by Jean-Pierre Bemba, was in South Africa giving order from there. They left that village spared from violence. They moved to loot the next village. He saved the life of thousands or hundreds of his constituents. This gentleman is the strongest supporter of the ICC jurisdiction in the parliament of the Central African Republic, because he was sitting hand in hand with other politicians who were warlords or elected and supported by those implicated in mass atrocity crimes allegedly committed by Seleka, Anti-Balaka, and other groups. So it's what I'm saying here is the ICC intervention is necessary, yet, for example, in Central African Republics, these politicians with others, they helped create the special criminal court for the Central African Republic within the judicial system of the country that is doing a good job, is incriminating the former head of state, and is doing is doing so with the support of the international community of the European Union, the United States, the African Union. There is a prosecutor from a neighboring country, and it's working. So it's an element, it's where complementarity works. But in most cases, it doesn't. And we need to create alliances to bring about trust into the international community, into the International Criminal Court, and of course, with the support of the international community, and have states like Somalia. The recent ratifications by, for example, by Armenia is testament to this. They felt abandoned by the international community, and they finally accepted the jurisdiction of the court for what had happened in Nagorno-Karabakh and is still happening at their borders with Azerbaijan. So it's a work in progress, but I think this is the biggest argument for states to join the system, to spread the universality, is because it's protecting their citizens, their individuals living in their territories, and having independent judges who are distanced from the battlefield can help. Not always. Sometimes you can have good transitional mechanisms, especially as time progresses, as we distance ourselves in the time frame from mass atrocities, we are more able as a mature society to generate our own domestic mechanisms very close to the victims, maybe more able to provide reparative justice, measures of restitution, compensation, and above all, rehabilitation. There's no doubt that's the responsibility of the territorial state. Yet, when we are facing the emergencies, and if we want to have a preventative effect, we need to have a pre-existing global international criminal court, and we need to fight to protect it.
Thank you. I cannot see any more questions from our audience. Oh no, there is one. Please, Mr. Mateusz Popier.
Hello, thank you for a great lecture. I've got two short questions. One a little bit similar to second question of Professor Hofmański. And you already talked a little bit about that over the universal jurisdiction. My first question is, do you have idea how to expand the ICC jurisdiction over states like USA, China, and Russia? And second question, maybe not politically correct, but maybe you heard about that case. My second question is, how do you assess Poland's behavior in case of Benjamin Netanyahu and the celebration of the liberation of the Auschwitz concentration camp? I think it was a month or two ago. Thank you very much.
Now, let's be clear, okay? And thank you for such interesting questions. The court does not have jurisdiction over states. Okay, so there is no jurisdiction of the court over USA, China, and Russia. There is not. All right, we are only talking about the individuals, and the court has already jurisdiction over any individual. For example, you are Polish. If an American comes to Poland with a plan to exterminate the Rome minority or to commit a genocide, is under the Rome Statute, because there is no exception based on nationality. The territorial, the two criteria are alternative. Same applies to Chinese. The Chinese individuals who would plan atrocity crimes in Cambodia. Cambodia is a state party, would fall under the jurisdiction as individuals, regardless of their nationality. But this is not a court for states. That's a big mistake that people make. And the crimes are not committed by states, are only committed by the individuals. States are committing unlawful, wrongful acts or unlawful violations of breaches of international law. And there is another regime, the regime of state responsibility, which is separate and distinct, and is very important. It's not functioning the way it should, but that's another lecture. Now, if your question means how can we bring about US, China, and Russia into the Rome Statute system, all right, then one has to be positive. Regarding the United States, it took 40 years after the adoption of the Genocide Convention for the United States to ratify the Genocide Convention. It was the year 1988, and it took a leader, a real leader, President Ronald Reagan, who can be criticized on many points, but he took many leadership decisions, especially vis-a-vis the framework of the Cold War. And he was shocked that the Senate had blocked for 40 years the bill to ratify, for the United States to ratify the Genocide Convention. Okay? By 2038, I am confident the United States will join the Rome Statute. Now, regarding the Russian Federation, as I told you, in 1998, Russia voted in favor of the Rome Statute. In 2000, before the entry into force, when the Russian delegate commented on the Rome Statute item in the United Nations General Assembly, it stated that entry into force and global ratification was an irreversible phenomenon, sort of applauding it. year 2000. Then, of course, things progressively changed, especially from the second Putin administration onwards. You know, I see Russia one day rejoining the Council of Europe, and then other treaties, and eventually also the Rome Statute, hopefully. And it happened in the past, that it was very close to do so. Why not in the future? Why not? Because the Russian culture is based on individual rights, and also Russians deserve to be protected by the Rome Statute. Regarding, so I'm not negative about the next or the second next administration of the Russian Federation to be enlightened and more multilateral in these approaches, and this will be to the detriment of the global peace, economy, culture, and so on and so forth, because certainly Russia, the Russian culture is one of the top cultures of the entire planet. Now, regarding the People's Republic of China, this is the most difficult question. And here I cannot be optimistic, and I need to be very honest. There is no possibility today to engage in promoting the ratification of the Rome Statute with a regime that is still based on a certain predicate, no? That there is the central committee of a certain political party that rules the entire system. So there is essentially, China doesn't have the rule of law. There is no separation of powers in China. I mean, nominally there is, and certainly many steps have been done to create some sort of economic freedoms in the population. So certainly things have changed since the times of Chairman Mao, but we are still under a very totalitarian regime to a certain extent, no? So unless that regime will be reformed, I don't see any hope for, and I don't forecast that this will happen soon, because of course there is a very strong system there, and the second economy of the world. I would hope, my only hope would be that China learns about the good dividends that stem from international criminal law and justice. Because in a world in which war crimes, crimes of humanity, genocide, and crimes of aggression are not committed, is a world where there is better freedom for all, more prosperity, free trade, more long-term security for investment, and so on and so forth. Because that's the language they speak. They want to become the largest economic power of the world. That's their goal as a nation. So maybe using that language, something can be achieved, but in the very long term, in my view. But thank you for such a smart question.
Thank you very much once again. I believe that we should already end because it's very late, and I am sure that we also have all questions already answered. So once again, thank you for your presentation and for being our guest today. And of course, I'd like to thank our audience for participation in this enlightening webinar. Of course, I invite you to check our websites and social media, because we intend to discuss the topic of international criminal justice in the future. So be sure to check the details for registration and other information about our upcoming webinars. So thank you once again for your participation, and we look forward to seeing you at our next event. So have a great week ahead.
Thank you very much.
Thank you, David. Thank you, everyone.
So much. Thank you.
Thank you very much.